everyone. Thank you so much for joining us today. We're going to be getting started with our webinar in just a few minutes here. As folks get logged in, I'd love to tell you about some upcoming webinars. On Wednesday, June 26th, we'll be having a webinar on workplace mistreatment, evidence of prevalence, antecedents, impacts, and intervention with Dr. Albert Shu and the California Labor Lab. We'll be taking the month of July off from our webinar series, so our next industrial hygiene webinar will be on Tuesday, August 13th, and that will be with the National Safety Council on their Work to Zero campaign. For more, you can visit us online at coeh.berkeley.edu/aboutce. And on behalf of education and research centers throughout the country, we're pleased to present the Industrial Hygiene Webinar Series. This is a collaborative effort on behalf of each Education and Research Center program in the continuing education departments. And our goal is to provide access to current research supported through NIOSH ERC programs and to spread the good word about topics like industrial hygiene. Thank you so much for joining us today. Today's webinar, Human Rights Due Diligence, New Laws for Global Supply Chains, is brought to you by Garrett Brown, MPH, CIH, and the Northern California Education and Research Center. A few housekeeping items before we get started. You are going to be muted during this presentation. If you'd like to ask a question, please enter it into the online Q&A, and we'll save time at the end of the presentation to address as many questions as possible. This presentation is being recorded and will be made available on the Center for Occupational and Environmental Health YouTube page within 5 business days. And all participants who logged in with their registration email for the full live presentation today will receive an email tomorrow with a link to an evaluation form that will qualify participants for a certificate of completion with 1 continuing education contact hour. Once the evaluation is completed, you'll be able to access and print your certificate. Without further ado, it's my pleasure to welcome our presenter for today, Garrett Brown, MPH, CIH. He has worked for more than 20 years as a field compliance officer and then special assistant to the chief of Cal OSHA before retiring. He also founded and is the volunteer coordinator of the Maquiladora Health and Safety Support Network, which has conducted projects in Mexico, Central America, Indonesia, China, and Bangladesh. Brown has written widely in professional and trade journals on effective methods to protect global supply chain workers. Thank you so much for being here today. We're really looking forward to your presentation and learning about these updates.
Great. Well, thank you very much. Let me go ahead and share my screen. Yeah, So thanks very much to Michelle and also to COEH for the opportunity to talk today. I've always enjoyed speaking to what's really a great resource nationally of OHS and industrial hygiene webinars around the country that are all free. So that's really amazing. So what I'd like to talk about today for the next 45 minutes or so is the status of global supply chains today. I did give a presentation with COEH last fall, September of 2023. So if people are interested in the subject matter, you can go back and look in the recordings for that one as well. Also touch on the history and the recent wave of regulations that are affecting global supply chains, what the strengths and weaknesses are of the 2 main new types of laws, one related to reporting and disclosure, and the other on due diligence. And then lastly, what impact this is going to have on the OHS profession and industrial hygienists in particular now and going forward. So the supply chain working conditions, as I mentioned, I spoke about at some length last fall, consist of the following: very long hours of work, very low pay, and entrenched poverty because of the low pay that's oftentimes delayed or underpaid, and amazingly pay that's never paid by employers in a wide number of industries and factories. They're unsafe and unhealthy conditions. There's a lot of physical abuse and sexual harassment, particularly against women workers in industries like the global clothing or apparel market, which is overwhelmingly female. There continues to be child labor, particularly in agricultural and food production, and forced labor in human trafficking, which is a new sort of category that the International Labor Organization, the UN agency, has begun tracking as well. So how do we know that this is actually true? Well, there are mainly 5 sources of information that people are interested in global supply chains can look at to find out what the working conditions are. There's the regular news media, which has periodic reports, oftentimes about, for example, in December, right before Christmas, you have children in China making toys for other children around the world because China produces 80% of the world's toys. There are factory reports, which are done by non-governmental organizations, NGOs, which oftentimes include testimony from workers in the plants themselves, as well as an analysis of its impact on the communities and the nature and the environment around it. There are reports from what's called multi-stakeholder initiatives, which are initiatives usually involving particular transnational brands, often clothing or electronics brands, combined with governmental organizations and non-governmental organizations to be a multi-stakeholder initiative. And they publish reports every couple of years on their factory base or on the sector that they come from, rather. Their CSR reports or corporate social responsibility reports from the transnational corporations themselves, which oftentimes are quite revealing, sometimes intentionally, sometimes not intentionally. But that's a good source of information. And then lastly, what's happened over the last 10 years or so is a development of an academic research literature, because CSR has been around basically for 30 years. So there are a lot of particularly business school professors that are interested in, does it work? Has it had any impact? And so there are a number of articles that have come out, particularly in the last 5 or 6 years, evaluating working conditions now and what impact, if any, CSR has had. And the latest is a sort of private sector investment benchmarking, which is interesting because, of course, these private sector investors are not against global capitalism. In fact, they want to invest in global capitalism, but they actually want the truth about what these global supply chains look like before they start investing in them. So just to give you an example of a couple of these, there's one of the benchmarks is called Know the Chain, which consists of 2 investment consulting companies and 2 NGOs. And a recent report they did in 2022 looked at 60 of the largest electronics firms, all the brand names that we know, and they had a set of criteria which was worth 100 points in terms of wages, hours, freedom of association, treatment of women and gender issues. And you can see the median score of these 60 corporations was just 14 points out of 100. And the highest scoring companies were HP, that had 63 out of 100. Intel had 60 out of 100. Cisco, Apple, and Samsung are all listed there as well. Interestingly, Know the Chain pointed out that 62% of these electronics companies source from what's called high-risk locations. That's locations around the world where there are numerous violations of workers' rights and environmental laws, adverse impacts to the community and the environment. And yet, of those 60 electronics firms, 45% of them failed to conduct any assessments of the impact of their operations in these high-risk locations. Another independent benchmark was called the Corporate Human Rights Benchmark, again involving private sector investors, and they looked at 110 apparel and extractive companies and put out a report last year, and their a score of 100 for the same wage and hour, freedom of association alike, found that 62% of apparel companies, these are all brand names well known to all of us, had scores below 20 out of 100. And 47% of the extractives, again, well-known mineral oil companies, were below 20 out of 100. And only 27% of these major corporations were found to have what they called responsible purchasing practices. So a third is the industry we want, which is primarily in the global apparel industry, which is 63 million workers around the world, and plus another 15 million in textile. related to it, so quite an important global industry. And they found, in looking at the wages in 28 countries around the world, and primarily the ones where garments are produced, that the minimum wage set by the national governments was 50% below what a living wage would be if the workers were paid a living wage. And the most interesting thing is that the survey of 1,400 factory owners found in 63 countries found that the brand purchasing practices, the so-called responsible sourcing policies and procedures, according to the factory owners who were the suppliers, the scores for the brands were only 48 out of 100. So as a result of 30 years of voluntary self-regulation by transnational corporations, I think it's fair to say, and this is what a lot of the B school research studies are indicating as well, that CSR has been successful in protecting the brand image of the corporations, the corporate reputation of the transnationals, and improving its public relations efforts with customers, investors, and the media. But CSR has been a complete failure when it comes to protecting workers' health and safety, workers' labor rights, and women workers in particular. So as a result of this 30 years of failure, then we have, one of the aspects of that is that people are finding the claims by the corporations less and less believable. So there was an organization called Blue Yonder that does annual reports on consumers' sustainability. And they put out one earlier this year, I think February, where they said that the survey indicated that among the millennials and the Generation Z, there was high concern for what's called environment, social, and governance issues, ESG, issues related to transnational operations around the world. But of the survey, only 48% of those surveyed trusted the brand claims only sometimes. 35% generally did not trust the brand claims at all, and 14% believed that claims are intentionally false. So as a result, the CSR, I think, has been a failure even on its success areas of the PR with consumers, investors, and the media. So I think there are basically three reasons why CSR has failed. And I spoke about this at length last fall, if people are interested in looking at that aspect of things. Just briefly, is that there are three key factors. One is the sweatshop business model in sourcing policies and practices by the transnationals in many different sectors around the economy and around the world. Secondly is an ineffective, really corrupted and secret monitoring process. There are CSR social monitors that go to these factories, but the only people they report to are the brands and the factories. This is not information that's available to the public. And there's tremendous conflicts of interest because all the CSR monitoring companies need to keep the brands as customers. And they learn quite quickly that if you give a relentless series of negative reports about any company's global supply chain, that company is simply going to find a different CSR monitor to look at their sourcing base. And then the third and an important factor in why CSR has failed is the lack of any meaningful participation by workers in developing, implementing, and maintaining CSR programs. We know as occupational health professionals that having genuine worker participation in all aspects of occupational safety and health programs on a factory basis is really key to having an effective program in the factories. So as a result of this failure over the last 30 years, there's been increasing amounts of regulatory response around the world where things have gone from voluntary self-reporting, self-enforcement through CSR to actually public regulation. So that started out here in California, which many things do, back in 2010 in the first Supply Chain Transparency Act, which was basically a reporting requirement that had no real effective enforcement mechanisms to it because it was basically the first one out of the block. But that set up a model, and as you can see, around the world, because of the failure of CSR, they've been increasing numbers and aspects of legal requirements for transnational corporations, starting in the UK, Netherlands, France, Australia. In 2021, despite the COVID pandemic, there was a big burst of due diligence laws in Germany, in the United States as well, and in the EU altogether. And again, this continued through 2022, 23, 24 in Switzerland, EU-wide, Canada, Mexico. And there's also proposed legislation now in the countries that are mentioned there. These things continue forward on issues such as child labor, forced labor, environmental aspects related to the Paris Agreement, pollution, deforestation, and the like. There's actually been a proposal in France to ban fast fashion, which produces these very cheaply made garments to be worn once or twice and then thrown away. Clothing and textile waste is part of these new proposed laws, as well as clothing with PFAS chemicals on them as well. So this regulation has also come to the United States. There was way back in 1930 a Tariff Act, which set out certain ability for the government to control objects or products coming into the United States if they violated certain criteria. And so that criteria is expanded over time to include issues related to environment, social, and governance issues. As I mentioned, California in 2010, there's been other federal laws in 2015 on a rule on human trafficking, a U.S. trade facilitation and trade enforcement, a Trump era law countering America's adversaries through sanctions Act of 2017, then the Uyghur Forced Labor Prevention Act, which has had a big impact on China and where the Uyghurs are, and also companies that are sourcing cotton and other materials produced in the Uyghur region of China. In 2021, California passed the Garment Worker Protection Act for the 30,000 garment workers that exist in Los Angeles. And last year, there was a California voluntary carbon market disclosure, which unfortunately the oil companies are suing to prevent enforcement in court. They also in the US mirrored the EU's Conflict Minerals Act that was passed here last year. There's also proposed legislation in the US. New York State wants to follow California's lead in terms of the fashion sustainability and social accountability law that was first proposed a couple of years ago, has not yet passed, but would be considered again this year. There's a national fashion accountability law called the Fabric Law, which is under consideration. God only knows when the US Congress would ever pass such a thing. But there are also rules by government agencies such as the Securities and Exchange Commission, which are requiring certifications of companies about their operations around the world. So you can see that this has really been a burgeoning burst of regulatory activity, especially over the last 3 or 4 years. And there's really two distinct types of regulations that are at play. One is the first is these mandatory reporting and disclosure standards, which was an effort to have somewhat standardized, comparable metrics used by everybody. And then secondly, the human rights due diligence laws, which started in Europe several years ago. And just this year, the EU adopted such a law, which will have a big impact on the 27 countries within the EU, but also will affect US corporations as well. So on the first, the idea behind the mandatory reporting is to promote regular disclosure on key ESG metrics, which is the when. Usually this is on an annual basis. To establish a process for reporting, that's the how this process of reporting will be done. Establish a set of consistent and comparable metrics, which is the what from this legislation. And the idea is to align these mandatory metrics with earlier efforts which took place in the UK in 2006 and Switzerland a couple years ago, and existing systems such as the Global Reporting Initiative, which some people may be familiar with from their own work, and the Sustainability Accounting Standards Board. That's the SASB, which sets out certain reporting requirements. So the goal here is to have a uniform, comparable set of metrics, because if everybody's looking at apples and oranges, then it's not very helpful, right? We want everybody to look all apples, all oranges, so we can compare. So this is a big question, is which metrics to use. And what it looks like is that there'll be a mix of both leading and lagging indicators. Those of us in industrial hygiene are familiar with those terms and looking at different aspects. A lagging indicator is what the injury experience would be of a company. A leading indicator would be what kind of inspections or trainings that are being done on a regular basis. Also in the mix will be so-called input-based versus outcomes-based metrics. So, for example, on working hours, an input-based metric would be whether the companies actually have written policies related to how long people can work, how much overtime people can work. The outcomes, which actually obviously are more important, is what the actual tally of regular and overtime hours are. So if there's going to be a metric by which these transnational corporations need to report, it's obviously good that they have written policies, but more important, what is the actual experience? In terms of gender discrimination, for another example, input-based would be about policies relating to harassment and violence, gender-based, also trainings that are conducted on that basis. But the outcomes would be more informative in the sense of what is the male to female wages ratio in the factory, what is the number of grievances or assaults that are reported in that factory, actual numbers about the outcomes. So the metrics is going to be a big deal for the reporting requirements. And so what was passed 2 years ago was the Corporate Sustainability Reporting Directive, which is on an EU basis. And it was to establish these European sustainability reporting standards, which would include these metrics that we're talking about: lagging indicators, leading indicators, input, output. But it's hard to do that in a fast way. So these new ESRS reporting standards were supposed to be ready by 2024, but in January of this year, they were put back for another 2 years. They had 2 years to develop in the first place, didn't succeed. So now they're putting it back till 2026, where the first set of firms in the EU will have to report on these metrics. Those are firms that have more than 500 employees. 2027 will be EU firms that have more than 250 employees and more than $50 million in euros, $40 million in euros by way of sales. And then 2029, the small and medium enterprises below 250 employees and non-EU firms, EU firms such as in the United States that have more sales revenues of 150 million euros. So the initial coverage is expected to be about 50,000 EU companies, which is not insignificant in terms of getting to a place where there's a standardized, uniform, comparable metrics being used to report out on ESG issues. There's also a development, what's called the Green Claims Code, which, if there was one in the United States, would be quite interesting, because what's required, this is the Green Claims Directive that was passed last year in the EU, and it went to an effect this year. And so it makes it illegal in the EU to sell products that are labeled eco or natural, because nobody knows what that means. So you can actually be sued and fined by government agencies if you put out the market products that say this is natural orange juice or natural tea, whatever it may be. Also, the Green Claims Directive bans products, claiming that the brand's products are carbon neutral if the only way they're carbon neutral if there's something else that offsets it. So, for example, if a company produces a product which actually contributes greenhouse gas, but then the company plants, 40 acres of trees to offset their product, they don't get to call that carbon neutral because the product itself is not carbon neutral. So the new Green Claims Directive also will allow only approved sustainable labels which have yet to be developed, and it can be enforced by civil suits and by fines from government agencies. So that's the first type of mandatory disclosure and reporting. The second is this human rights due diligence, which is a concept that's been around for a while, but is now in full flower in the EU. And the goal of this is to require transnational corporations that do business in the EU, which would include US corporations, with supply chains around the world. These transnational corporations on an annual basis will now have to identify and assess actual or potential impacts on people and nature of their operations, take appropriate action to correct the adverse impact, track the effectiveness of these measures taken, and communicate the results to the affected stakeholders and communities. So if you're a mining company in in the Andes, you're going to have to track your impact on this community and then report to the community itself as to what the impacts have been, what the countermeasures are, whether they're effective or not. And then also the transnationals will need to issue standardized comparable reporting, which will be along the lines of this previous European directive that we spoke about. So the attempt here is to cover the entire product life cycle in tiers 1, which is the supplier that produces, say, Apple computers, their first tier supplier like Foxconn or other Taiwanese companies. Tier 2 would be the suppliers that provide the tier 1 with the parts needed for that. Tiers 3 and 4 are sometimes used interchangeably. It's the raw materials or zippers or things like that that are made for cotton, for example, cotton for clothing in the supply chain. So the HRDD will cover upstream operations, which includes the development of raw materials such as cotton, which is why the Uyghur Forced Labor Act has had an impact already on companies that are sourcing cotton from China. Design and production systems will also be covered by the due diligence laws. And then downstream as well, related to the distribution, transport, and storage of the products that are produced by the transnationals. HRDD will not impact, at this point, recycling or disposal, which are big issues. The waste issue in the form of in clothing and in electronics is really a big concern. So the examples that HRDD is now going to cover would be the fast fashion factories in Asia, for example, producing clothing, electronics factories in Asia producing all the computers that we use, could be for mining for minerals in Latin America, or fossil fuel production like oil in the Niger Delta and in the Amazon. All of those companies will now be, if they are functioning in the EU, which they are, will be covered by these due diligence laws. So what exactly are the companies going to have to report on? So the human rights impact areas are what's listed here on the screen. You can see it's quite a broad array of impacts potentially to workers, to the communities, and to nature. Wages, hours, health and safety, gender-based issues, the climate carbon goals that were set by the Paris Agreement are part of this, pollutions, and indirectly the waste impacts, and also importantly, the impact of the companies on corruption and ethical business practices. Because as we know, in many countries that are part of global supply chains, corruption is endemic. And in certain aspects, it's been condoned or even facilitated by the practices of the transnational corporations who are happy to pay, for example, a corrupt government official X amount of money rather than to actually have their factories in that country meet the environmental or occupational health requirements that exist under the law. Easier to pay a bribe than it is to actually meet the law. So these corruption and ethical business practices are going to be part of HRDD as well. So the criteria that's going to be used for these impact assessments are international standards, including the International Labor Organization's core conventions and the fundamental rights which affect health and safety, but also things like wages and hours, the right to form a union, the right to have collective bargaining, the abolition of child labor and forced labor. Those are all ILO conventions and fundamental rights. In 2011, the UN put out guiding principles on business and human rights, which was updated after a fashion by the Organization of Economic Cooperation and Development in 2018, their due diligence guidance for responsible business conduct. So these will be part of the criteria that will form the basis for the metrics that the companies will have to report on an annual basis. So these human rights assessments also need to include an evaluation of the management systems of the companies. That is, how effective are they in actually identifying and mitigating hazards caused by their operations? What are the efficacy of the preventive and the corrective measures? These assessments, in theory, would include evaluations to suppliers all the way down from tier 1, which is where most of the publicity and reporting is taking place presently, down to tier 2 and down to tier 3 and 4. I don't think we'll see that for a while, but in theory, that's where HRDD is headed. It's also going to be a priority on high-risk locations, like those 60 electronics companies that one of the investor benchmarkings were looking at, that they noticed that there were 62% of them were operating in high-risk locations. So this would be a particular priority for the HRDD reporting. And the idea behind it really is to establish a level playing field among corporations, because there are some corporations like Nike, for example, or Apple, that are high profile and have been the subject of a lot of consumer campaigns and student campaigns around sweatshop business practices. And so they've been forced in order to improve their functioning, but they also don't want to let their competitors, especially low road competitors, get away with having working conditions that they themselves can no longer conduct because they can't do so for publicity purposes. So that's the theory behind HRDD. Now, some people might look at this tremendously long list of assessments and the reporting requirements and say, wow, is this overkill? And the business community itself is sort of split on that concept because, as I mentioned, the companies that are already the poster child for sweatshop operations are in favor of due diligence because they want everybody else, all their competitors, to meet what they're having to do themselves. And there are other businesses that say, no, this is an overreach on the part of the government. But in my view, in any case, I think it's not an overkill. It's a step forward because many transnational corporations continue to behave badly in their operations around the world with workers, with communities, with nature. And as I mentioned earlier, the voluntary, secretive CSR self-regulation has failed spectacularly in terms of improving working conditions in global supply chains. So let me tell you that the business of making legislation in the EU, the making the sausage, as it's often called here in the United States, is pretty much the same. But this is an important law that was just passed and which will have, as I mentioned, an impact on EU corporations, but also on US corporations working in the EU. So this, it's always an acronym. This is the Corporate Sustainability Due Diligence Directive, or CSDDD. So CSDDD has really been a concept that was first raised in 2016. And then negotiations began between the business community and the unions and NGOs in 2020. And there was actually an agreement announced in December of 2023 that the CSDDD had been agreed to and was going to be sent to the European Parliament for approval. But then that agreement was actually blocked by Germany, France, and Italy in February of this year. There was a revised agreement that was passed in March after intense negotiations between Germany, France, and the others. And then the EU Parliament itself approved this new law on April 24th, which is the anniversary, of course, of the terrible Rana Plaza building collapse in Dhaka, Bangladesh, which killed 1,100 people in 2013. So on the very day, the 11th anniversary of that disaster, the law was passed by the parliament, and it was officially adopted by the European Union last month on the 24th of May. So the original CSDDD had the following requirements. It was the broad human rights assessment, including the climate plans, corporate climate plans to meet the Paris Agreement, subsidiaries, suppliers, the risk-based approach, prioritizing a broad list of high-risk sectors, which including manufacturing like textile, clothing, footwear, agricultural sectors like forestry and fishing, mineral extraction, and also construction. Those were all high-risk sectors. And then there was the final thresholds after a five-year phase-in period where it would start at 500 employees in a company where it would cross the threshold and be covered by due diligence if they met the sales, down to 250 employees in 40 million euro sales for so-called high-risk companies. The original CSDDD also allowed affected stakeholders, including NGOs and unions, to file civil liability claims for 5 years. Financial services were not included, but future inclusion was possible. The reporting was to be aligned with the CSRD that I talked about earlier, and the penalties are quite significant if they were to be issued by national authorities for companies that violated the due diligence laws. That could be as much as 5% of the global sales, which could be millions of euros or dollars. And this is the original mandatory start in 2027. So it was blocked, as I mentioned, by Germany, France, and Italy, and it had sort of basically the standard arguments against it, which were kind of ironic because Germany already had a supply chain law in effect from 2021. But they wanted to tweak this, going to be this EU-wide, which would set a new floor for all of these laws, including ones that exist in Norway and France and Germany. So there was an intense period of 2 weeks of negotiations, and the results were what everybody agreed was a watered down agreement. And what was approved and is now in effect in the EU is that the revised provisions were that the final thresholds were raised to 1,000 employees in a company with 450 million euro sales, which is a jump up from what the original proposal is. This actually eliminates 70% of the covered companies in the original CSDDD, but it still means that an estimated 53 companies in the EU, 5,300 rather, companies in the EU would be covered by the due diligence laws. What was deleted in the revised and approved version was a priority on high-risk sectors, which is kind of problematic since that's where most of the violations occur. The financial sector of investment bankers was permanently excluded, and the ILO fundamental right, which was added in 2022 to include occupational safety and health, was not included. The new due diligence laws only include the four fundamental rights of the ILO, which is on freedom of association, collective bargaining, child labor, and forced labor, and does not include the occupational safety and health, despite the fact that it was adopted as the fifth fundamental right in 2022. But the retained provisions include the human rights impact assessments that need to be done, the public reporting, meaningful stakeholder engagement, corporate climate change plan is required. There's the financial penalties of up to 5% are still retained, and also retained of the civil liability provisions. There is a long phase-in period here. As I mentioned, the reporting directives got a 2-year delay. It now starts in 2026. And the CSDDD was approved in May of 2024, but it's actually going to have a 2-year period where each of the 27 countries have to adopt national legislation to be in coincidence with the EU law. And it would start in 2027 with the largest companies of over 5,000 employees. and wouldn't affect the smallest ones, which are over 1,000 employees, until 2029, a 5-year period. So the question is, for many, is this a glass half full or glass half empty? There are, of course, some significant carve-outs. The small and medium enterprises with less than 1,000 employees basically are exempted from the law. The high-risk sectors that have less than 1,000 employees also exempted. OHS is not viewed as a fundamental right. Disposal and recycling and waste issues are not included at this point. And then, of course, the investment sector is also excluded. But in my view, I think it is a qualitative improvement and advancement over CSR. There are mandatory assessments required, there's mandatory public reporting, and there's meaningful penalties that are being associated with it. And I think most importantly, it strengthens the abilities of workers and communities to defend themselves, because based on this information, they can file complaints against specific companies for specific operations in their community. They can wage publicity campaigns. They can file lawsuits, all the like. So I think the ability of workers and communities to defend themselves based on the information provided by the CSDDD is a big advantage, and where real progress is going to happen in terms of improving working conditions. So there are 3 major weaknesses in my view here. The first of which is who's going to do the assessments, right? So one of the problems with CSR was that you had this whole cottage industry of CSR consultants who did very poor assessments themselves for lack of technical ability, and also because of the conflict of interest that I mentioned earlier. So we have the same issue here for these human rights assessments under CSDDD. Is it going to be corporate self-reporting? Is it going to be back to CSR consultants, which I think are completely discredited at this time, both on the issue of accuracy of the assessments and the conflict. And then also which metrics are going to be used. I mean, if we have a jungle, if we have just a mismatch of all the metrics by company or by sector, industrial sector, that's not going to allow for us really to have comparable standardized reporting. And it's the issues that I mentioned earlier about outcomes-based metrics as well as the inputs. There are some examples that people are trying to think about this. Cornell University's Global Labor Institute just this month put out its proposal for 25 labor-oriented metrics, which it hopes to be adopted in the reporting requirements as they're developed over the next couple of years. And there are others, of course, that are being proposed as well. A second major weakness is, will there be the resources and capacity, and most importantly, the political will to actually enforce CSDDD on the part of the EU Commission, which is the executive branch of the European Union's government, but most importantly by the EU governments, which have to pass this law into national legislation and then establish supervisory organizations that would actually do the investigations, receive the complaints, investigate the complaints, and issue fines and penalties as needed. And then, of course, you have the developing world governments. Many governments in the developing world do not enforce their own regulations now because they don't want to discourage foreign investment in their country, which if they actually enforced environmental or occupational health laws, companies perhaps would go somewhere else to set up their operations. So there's going to be a big question is, with the law, can actually enforce it by these 3 key players? And then lastly, and also very importantly, is, will workers and communities really have a genuinely meaningful role in the development of the assessments, in the evaluation of the corrective action, and in terms of evaluating the effectiveness of the company's reporting of the hazards that they are experiencing themselves? So a meaningful role would mean that workers and communities would be involved in the design and conclusions of any assessment, the design and implementation and the verification that it works, preventive and corrective actions, and then have the ability to contest corporate assessments with civil complaints and claims. So in my view, the best fix, I think, for these problems, particularly the first and the third problem, is to adopt the approach of what's being called worker-driven social responsibility, or WSR. That's sort of the worker alternative to CSR. And there's a track history, which I'll talk about in a second for that. But the key is to have effective worker voice in establishing and implementing the protocols for assessments, which is easiestly done, of course, if you have unions. You can have the unions part of this process. Now, in many global supply chains, unfortunately, there are no unions. And so it's going to be a question of how can worker centers or human rights organizations or women's rights organizations have a meaningful role as representatives of workers in this assessment process, and also in filing effective complaints under the CSDDD. So if this is a long story about what is WSR and how does it work, et cetera. So I put the URLs there for the WSR network website based in New York that has all the information about what this is. There are a couple of things they've been doing for about 10 years now. In the United States, they have a fair food program based in Florida with the tomato pickers in Florida. You may have heard the Immokalee Workers Coalition has set up this fair food program. In Vermont, there's a Milk with Dignity program, again, worker-driven social responsibility programs with mostly Latino immigrant workers and dairies. They're expanding the work now for construction contractors because a lot of the contractors use day laborers who are Latino or immigrants from different parts of the world. So that's in the United States. Internationally, WSR has had a 10-year track record, more actually in Bangladesh, and internationally now in Pakistan as well, with the Accord, which was in the aftermath of the Rana Plaza disaster, established a health and safety program, which also had aspects around workers' rights as well. There have been some binding brand agreements and an agreement between a brand and NGOs and unions around issues of freedom of association and also gender-based violence and harassment. And then many of the global trade unions have established what's called global framework agreements with major corporations, steel production, others, that where the unions and the company have agreed on a minimum standard of their operations around the world. So there's a history here of successful operations involving the WSR approach. So the question is, of course, whether this will work. And in the words of the philosopher Yogi Berra, it's very difficult to make predictions. And the devil is in the details, particularly on how the metrics are going to be developed, how the reporting requirements. It's important to understand that there's no one silver bullet to improve working conditions in global supply chains. The reason why they're still bad 30 years after the advent of corporate social responsibility is because it's very profitable for corporations to have bad working conditions and maximize their profits out of supply chains. So it needs for us to sort of fire on all cylinders. I think the due diligence laws will be one activity that's very important to use in terms of pressure, getting information, applying pressure on corporations a lot, but it has to be combined with other activities. I mean, in terms of internal advocacy within the transnational corporations by industrial hygienists or others, media campaigns about working conditions, organized consumer campaigns have been very helpful in the past, organizing support for workers who are on strike or are trying to get a union established. The investor campaigns have been very effective in drawing attention to bad working conditions at stockholder meetings, for example. Public procurement contracting, where government agencies require certain standards to be met by their suppliers, say of computers or of clothing. There's a legal strategy in terms of lawsuits and trade agreements such as NAFTA and its replacement. And then there's capacity building strategies to actually build the awareness on OHS issues and their skills of worker and community organizations. So all these different strategies need to be combined, as well as the due diligence law, to have a lasting and sustainable impact on working conditions. So that's just to finalize here. There are, I think, going to be some big impacts for our profession from these laws, because these reporting laws and the due diligence laws, they're going forward, as I mentioned, not only the laws that have been passed, but the ones that have been proposed as well. And so industrial hygienists and other OHS professionals are going to find themselves, starting in 2027 forward, as part of a broad assessment process of what working conditions are and what in global supply chains in tiers 1, tier 2, tier 3. So it means that IHs will be members of multidisciplinary teams. They'll have to expand the OHS and IH work that we're doing already throughout the supply chains. And IHs will be part of teams that will have to have subject matter assessments on things which typically we don't know as well as we do IH. So there are many people involved in environmental health, but it's going to be expanded. There are international standards such as the ILO standards I mentioned, or the UN guiding principles, or the OECD guiding principles. And then there are also social standards in terms of maternity laws, laws around gender-based violence and harassment, which, as part of the teams, occupational health professionals will have to be familiar with. So there's going to be a new skill sets needed. We have to learn how to be effective participants in teams as opposed to being siloed as we often are today. New subject areas, as I mentioned, we'll have to get up to speed on. And there's also some soft skills, I think, that are going to be important for OHS professionals to further development as part of these due diligence assessments. That's effective communication skills, effective interview interaction skills, particularly with workers and community groups, and having the cultural and emotional literacy. That's to use a phrase that's being sort of a new field these days, emotional literacy and cultural literacy, to deal with supply chains that are outside the United States and are in the developing world. So in the end of the day, I think that HRDD will be positive for the OHS community. It raises the profile of worker health and safety. It moves OHS and environmental health to the center of human rights concerns. And I think it enriches our professional lives, that we expand our body of knowledge and we expand the work we do and the people we do it with. Now, the negatives, though, I'd be concerned about for our profession is that we might be potentially enmeshed in CSR's fatal flaws, which were particularly the integrity of the assessments, whether there'll be these conflicts of interest, which have really just been a fatal flaw for CSR monitoring and activities for the last 30 years. So we'll have to figure out how it is to avoid getting enmeshed in all of that. But I think what we can do for a better supply chains as occupational health professionals at work is to be advocates within our companies at home and abroad for effective programs. As consumers, we can demand that the brands and retailers obey the law and make good on their promises. As citizens, we can demand that the governments do their job to protect workers at home and abroad, particularly with these new laws affecting US corporations as well. And as OHS professionals in society, there are any number of OHS initiatives and capacity building projects. The American Industrial Hygiene Association's Northern California section has the Developing World Outreach Initiative. There's the Worker Health Without Borders, Workplace Health Without Borders, based in Canada, but also has affiliates in the United States and other parts of the world. So there are opportunities for OHS professionals to actually make a contribution on an individual level, as well as citizens, as consumers, and as professionals. So I'll leave it there, and I'm happy to answer any questions that people might have.
Wonderful. Thank you so much for your excellent presentation. At this time, to our online learners, you are welcome to enter any questions that you might have into the Q&A. First question, do you see the ANSI ASSP 16.1 Occupational Safety and Health Metric Standards as helpful to the CSR/worker rights improvement effort?
Well, that's a good question. There are a lot of different schemas out there in terms of which metrics to use. Part of the problem with CSR is that every company had its own set of metrics, and every sector, clothing had one set, electronics had another set. So, the devil's in the details. I think it'll be very important for establishing a set of metrics that look, as I say, both leading and lagging indicators, both input based and outcomes based. I'm not that familiar, to tell you the truth, with that particular ANSI standard, but there's lots, it's like the ANSI standard or the AIHA, health and safety management system standards. They're all slightly different from one another. So it's going to be somebody's job to have all the inputs from these different metrics and establish one that will be the reporting requirement for all of these assessments.
Thank you so much. You also mentioned some penalties for non-compliance. Has there been any indication on what those would be?
Yeah, so it's different. As I mentioned, there's probably 24 laws that are already in effect in Europe and different parts of the world, either on reporting or on supply chain management. So you have to look at each of the particular laws. That usually they're monetary penalties, and they can also be civil fines for the governments or the agencies involved. With the new CSDDD, what they're talking about is fines up to 5% of the global sales of a corporation. So if you look at who's, if you have to have 450 million euros to pass the threshold, and in sales, 5% of 450 million euros is quite a hefty fine. I doubt they'd start at the upper end, but that's certainly where they could go if the national government's supervisory authority thought that the company involved was not behaving badly.
Thank you. Has the World Bank brought into this and made lending Has the World Bank been brought into this and made lending policies contingent on compliance with HRDD?
No, and that's one of the big weaknesses that I mentioned, is that the financial sector, including government financial institutions, are not covered by HRDD. The World Bank, as you may know, already has a policy where they have very limited requirements on loans, requirements related to health and safety. They have lots of requirements on the World Bank on how to handle the money, how it's to be, where it's to be handled and given out, et cetera. But about 10 years ago, they started issuing small snippets of health and safety requirements, which were very generic. It was mostly around World Bank infrastructure programs like big dams, big roads, power stations, and the like. And so it was very thin, the World Bank OHS requirements. And oftentimes they had nobody who was an industrial hygienist or an OHS professional capable and competent to evaluate whether the project was actually meeting them. But that's another area which, of course, would be good to have all of the financial institutions, private sector as well as public sector, involved in getting behind what the standards are and what the reporting requirements would be.
Thank you. What do you think, or where do you think are the biggest opportunities for Tier 4 and raw material suppliers for global compliance?
Yeah, that's really the toughest one of the lot, because you're dealing with oftentimes small farmers. I mean, if you look at West Africa, for example, with the cacao plantations, they have big plantations, and then you also have small farmers producing chocolate that we all like to eat. Tremendous levels of child labor there. So how are you going to deal with that? Or the India rug industry, for example, also tremendous amounts of child labor. So there have been different NGO primarily efforts to try and reduce that. Here, in theory, I don't think it'll happen right away, but in theory, Nestle's, the chocolate Swiss company, Swiss chocolate company, would be responsible for doing HRDD assessments in its suppliers in West Africa, which would include all the other elements, including child labor, forced labor, health and safety, et cetera, that would be applied elsewhere. I think that's some place down the road, because it'd be great if we had these kind of assessments in Tier 1 or Tier 2 to begin with. And that would be a big step forward. Getting to, or the Uyghurs in Western China, the reports that are given to Congress indicate that there's still problems there. although it's mixed up with politics because there's some congressmen that don't like China no matter what. But there are, I think, elements of trying to get at the tier 4, which are going to take some thinking as to how to make that effective.
Thank you. I think we have time for one more question. How would we impact the workers at the beginning of the supply chain in some of these third world countries to feel that they have a voice in bringing their concerns to light? In my experience, most feel they have a job and don't want to necessarily do anything to rock the boat or change the status quo.
Right. Well, in most global supply chains, workers don't have unions. And I would suggest it's not because they don't want unions, it's because the level of employer retaliation and reprisals against workers who try and form unions is so severe that nobody who has, a family to feed or a roof to pay for, rent to pay for, is in a position to do it. So ostensibly, this would be a requirement too, because one of the four requirements, fundamental rights under the ILO is the right to form unions under freedom of association and the right to collectively bargain. So those will be part of the assessments, and they will be pressure points that will hopefully allow workers in Bangladesh or in Africa or in Latin America who would like to have a union but are fearful for having a union to move forward with that, or at least have their worker centers or their women's rights organization or their human rights organization recognized as a worker representative as part of this process.
Thank you so much for your time, for your presentation, and all of this information. Thank you to everyone who joined us online for this training as well. As a reminder, you'll receive an email with a link to the evaluation form to qualify you for a certificate of completion with one continuing education contact hour. And again, thank you all for being here. I hope you have a wonderful day. You can learn more about other upcoming events and webinars at coeh@berkeley.edu/about CE. Have a great day.
Thank you.
Thanks.